Bray Gillespie is another good case in Florida to know about. We've talked about it before. This is a poor dead bunny case where they stripped the metadata so it couldn't speak its bunny language in order to reveal which of the 100,000 emails went with which of the 100,000 attachments. Remember that. The brilliant attorneys for the plaintiff here decided that they weren't going to share that information, and as a result, they forced the court to have 2 evidentiary hearings, taking up a lot of time, making the court upset, rightfully so, with the attorneys that would do that. A major national law firm, by the way. The law firm itself was sanctioned, not only the attorneys. This is something the judges here in Florida and elsewhere are not going to tolerate, this kind of not only non-cooperation, just kind of mean-spirited, I'm not going to produce it because I don't want to. And maybe it was done, we can hope that maybe it wasn't done just as an intentional bad tactic, it was just done out of ignorance, but it doesn't matter. Ignorance is not a defense anymore. Blunders it may be, but the bottom line is it forced the court to waste a lot of its time, so sanctions were imposed. You want to avoid this. You want to make sure you don't play games and try and hide metadata. It's never worth it. Yeah.
The 2 evidentiary hearings on the 26th conference that you talk about, is that a 16B hearing?
No, it was after. I don't know this for a fact, but I doubt a 16B hearing was held there because it's the practice of the Middle District not to have 16B hearings unless the attorneys request it. I believe that's the practice of most district courts around the country. And so the attorneys didn't request it, so they never had a 16B hearing. This came after a motion for sanctions when one side said, hey, you said it was okay just to take strip TIFF production. You didn't ask for full metadata. That's what the plaintiff's counsel said. You never raised this at the 26F. The defense counsel said, no, it's not true. We asked you for it. We discussed it at 26F. So one lawyer says one thing happened, another lawyer says another. This is not that unusual. What is unusual is the judge said, wait a minute, I want to really find out what happened. We're going to have another hearing, and you're going to be sworn under oath, and we're going to testify, and I'm going to find out what really happened. This suddenly makes one side very nervous, the side that was stretching the truth. And so she did it. She did the hard work of, so these hearings were about, well, what went on, what was said. That's why probably if you're going to 26F conferences and you're doing the right thing, you're making meticulous notes of what is said and what the agreements are, and you're having a report that memorializes it. I'm not saying it right. What is it? Thank you. Memorializes it so that there's no dispute later on. You don't get into, well, who said what at a 26F conference. Go ahead and put it in your report, which, by the way, the defendant in the request for production, even if there was a dispute on the report, they specifically asked for metadata. So when you make your request for production and you want metadata, say so. That's another critical lesson in metadata. If you don't really care, then you don't have to say so. But a lot of times you do care. Like, for instance, if you want to know what attachments or with what emails, you might want to make sure that the other side gets that so that they won't say, oh, I didn't know he wanted to know what attachments were with what emails. Although, I mean, come on. That's an incredible assertion to make, that you assume the person wouldn't care what attachments there were, and so it wouldn't have worked with this court anyway because it was an unreasonable assertion. So that's Bray and Gillespie. You can't just pretend like, the law firm just can't pretend like, oh, well, I don't know. The law firm itself got sanctioned, not just the lawyers. Bray and Gillespie, too, these same lawyers kept at it. This is the hotel records thing where they didn't produce the electronic records of people checking in and out of the hotel because they said they didn't think that was possible. They would have to only produce the paper. Bottom line is they produced SQL database printouts only after they had depositions of the experts involved, making the expert depositions a waste of time, forcing a complete redo on all of that. The defendant said, enough's enough. This is the same lawyers that did it. Actually, there was slightly different lawyers were involved. This time the local Orlando lawyers got sanctioned here, not just the big firm. And so the magistrate recommended the case be dismissed with prejudice. This is still, we're awaiting ruling on it. This is, you know, this is current, what's going on. Personally, I don't have any connection with the case, but I would be surprised if the magistrate's recommendation is not followed, which means game over, they just lost. They had a $4 million claim that they blew by over-aggressive, non-cooperative, unreasonable approach to e-discovery by otherwise sophisticated attorneys. So this is the reality. It's not just me saying it. This is what the judges are writing about in their opinions.